Chapter 3 Company Law, Members and Shareholders. So members and shareholders la members அப்படினா என்ன? Members is your name is registered in the company and your name is mentioned in the register of members. So company's name la வந்து register of members ROM la வந்து your name is registered, so he is called as a member. Who is a shareholder? A shareholder, when you buy the shares of a company, or company oda shares buy பண்ணும்போது and it comes to your account, immediately you become a shareholder. So it is you are holding shares of the company. So in the chapter it is a very important chapter in your syllabus. இந்த சாப்டர்ல இருந்து நீங்க வந்து உங்களுக்கு வந்து அட்லீஸ்ட் 8 to 10 மார்க்ஸ் வரையும் எக்ஸாம்ல வந்து क्वेश्चंस கேட்பாங்க. ஸோ நம்ம அப்படியே சாப்டருக்குள்ளே வந்தோம்னா we have the concept of membership. What is the concept of membership? So in the case of a company limited by shares, the shareholders are the members. Okay, ஒரு company which is limited by shares, அந்த கம்பெனியில் இருக்கிற ஷேர் ஹோல்டர்ஸ் தான் வந்து அந்த கம்பெனியோட மெம்பர்ஸும். So the terms members and shareholders are usually used interchangeably, as there can be no membership except through the medium of shareholding. Thus every shareholder is a member and every member is not a shareholder. Okay, so however there may be exceptions to this statement. Example, a person so however there may be exceptions to the statement. Example, a person may be a holder of shares by transfer but will not become its members until the transfer is registered in the books of the company in his favor and his name is entered in the register of members. Similarly, a member who has transferred his shares, though he does not hold any shares, yet he continues to be a member of the company until the transfer is registered in his name, is removed from the register of members maintained in the company. ஸோ நம்ம இங்கே ஸ்க்ரீனில் வந்து நான் வந்து மாடியூல் வந்து ஷேர் பண்ணிக்கிறேன். ஸோ நீங்கள் உங்கள் புக்ஸ் எடுத்து வச்சுட்டு யூ கேன் மார்க் தி இம்பார்ட்டண்ட் பாயிண்ட்ஸ் விச் ஐ மார்க். ஸோ டெஃபினிஷன் ஆஃப் மெம்பர். ஸோ அக்கார்டிங் டு செக்ஷன் 2 clause 55 ஆஃப் Companies Act 2013. Yes. So here we have the first one, the subscribers to the memorandum of the company who shall be deemed to have agreed to become members of the company and on its registration shall be entered as members in its register of members. So you can like read it, guys. You வந்து இதை வந்து read பண்ணா போதும். It is not very much important, the definition of the member. So next one is every other person who agrees in writing to become a member of a company and whose name is registered in its register of members shall be a member of the company. So நான் சொன்ன மாதிரி whose name யாரோட பேர் வந்து கம்பெனியோட ரெஜிஸ்டர் ஆஃப் மெம்பர்ஸ்க்கு தனி ரெஜிஸ்டர் இருக்கும். அந்த ரெஜிஸ்டர் ஆஃப் மெம்பர்ஸில் யார் பேர்லாம் இருக்கோ they are said or called as a member. Okay, and next third one is every person holding shares of the company and whose name is entered as a beneficial owner in records of the depository shall be deemed to be a member of the concerned company. Okay, so yeah, so guys உங்களுக்கு வந்து closing of registers அப்படினா என்ன தெரியுமா? what is closing of registers? A closing of register, the registers are closed mostly before the meeting when the dividend is declared. Okay, the registers are closed mostly மீட்டிங்க்கு முன்னாடி the register are closed எப்பனா dividend வந்து declare பண்ணும்போது. So dividend அப்படினா என்ன? What is dividend here? So closing of registers na, the registers are closed mostly before the meeting when the dividend is declared. So what is dividend? It is the distribution of company's profits to its eligible shareholders. So the word eligible is important here. Distribution of company's profits to its eligible shareholders. So this is known as dividend. Next one then our topic introduce பண்ண போறேன், which is NSDL and CDSL. So these are the depositories of India, depositories in India. So they are the registered owners for all listed company shares. So they are the registered owners for all listed company shares. Okay, so when someone buys the share, they become யாராவது கம்பெனிஸோட எந்த கம்பெனியோட ரேண்டமாக ஒரு கம்பெனியோட ஷேர் பை பண்ணாங்கன்னா these depositories will become the beneficial owners of the shares. They will become the beneficial owners of the shares. So in the beneficial owners na enna benefits la irukum? So all the benefits arising due to ownership of shares. The ownership of shares own பண்றாங்கல எல்லா கம்பெனில இருக்கிற ஷேர்ஸ்லாம் அந்த ownership of shares is received by them. Enna benefits? Dividends, bonus or split edavadhu nadadha, they will receive the benefits. Next topic enna, how to become a member. How to become a member. So we have 3 modes of acquiring membership. Membership acquire பண்றதுக்கு we have 3 modes. First one is subscribers to the by subscription to MOA and AOA. MOA and AOA க்கு வந்து subscribe பண்றது. And second one is by an agreement for transfer of shares, transfer and transmission. And third is holding shares as beneficiary in electronic form. Holding shares as beneficiary in electronic form. So the modes of acquisition of membership is under section 2 clause 55 of Companies Act 2013. First we have the by application and allotment. So it is done by subscription of shares by application and allotment of MOA and AOA. So இது எப்போ நடக்கும்னா it is done before the incorporation of the company. So company incorporate பண்றதுக்கு முன்னாடியே they will subscribe to the MOA and AOA of the company. Second is by transfer of shares. Second is by transfer of shares. And third is by transmission of shares. Third is by transmission of shares. Fourth by acquisitions or estoppel. What is estoppel? So you are given an opportunity to refuse to something, but refuse to membership, okay, but you choose not to. It is called estoppel. So next we have who may become a member. யாரெல்லாம் வந்து மெம்பரா இருக்கலாம்? Member of a company. Who can become a member of a company? So yeah, who can become a member? First we have, can an individual become a member? Yes. Can a company become a member? Yes. Can a partnership firm become a member? No, because it is not a separate legal entity. However, the partners in the individual capacity can become a member. However, it can become a member of section 8 companies. Okay. Next, can a foreigner become a member? Yes, it depends upon the foreign laws. But in the events of war, he becomes an alien enemy like Pakistan, and his power of voting and his right to receive notice is suspended. Okay. Next is, can a minor become a member? Yes, but only through a natural guardian, and only if the shares are fully paid up. Okay. Can a trade union become a member? Yes. Can shares in fictitious names na அந்த individual வந்து is not even in the world, can he become a member? No. Can an insolvent company or an insolvent individual become a member? No. ஏன்னா the liability, so insolvent person or insolvent company ஏன் வந்து அப்படின்னா என்ன அப்படின்னா the liability is more than the assets. Okay, so they go to the court and the court declares that person insolvent. So when you become insolvent, the court appoints a receiver or an assignee. So நீங்கள் உங்களோட assets எல்லாமே that receiver or assignee will take part into. Next வந்து can section 8 company become a member? Yes. Can an HUF become a member? Can an HUF become a member? No, but yes in the name of Karta, who is the head of the family. Can a society become a member? Yes. Can a receiver become a member? It is yes as well as no in some exceptional cases. Here we have the next topic is Global Depository Receipts, which is GDRS, as per Depository Receipts Scheme 2014. So what is GDRS? Global Depository Receipts. It is very important. So நான் சொன்ன மாதிரி what are the Indian depositories? What are the Indian depositories? NSDL and CDSL. So it is any instrument in the form of a depository receipt by whatever name called created by a foreign depository outside India. Okay, and it is authorized by an Indian company making such issue of DRs, which is depository receipts. So the depository receipts can be issued by way of public offering or private placement or in any other manner prevalent in the concerned jurisdiction, and may be listed or traded on the listing or trading platform in the concerned jurisdiction. So the process of issue of depository receipts may be remitted in an international financial services bank, central bank unit IBU, and utilized in accordance with the instructions issued by the RBI from time to time. So GDRS அப்படினா, for example, ஒரு Indian company இருக்கு. That Indian company wants to buy wants foreign investors. Okay, அவங்களுக்கு வந்து investors இந்தியாக்குள்ள வேணா, they want foreign investors. Okay, so here is the Indian company. They want foreign investors. They are here. ஸோ வந்து ஃபாரின் இன்வெஸ்டர்ஸ் கிட்ட வந்து கேட்குறாங்க, நீங்கள் வந்து எங்கள் கம்பெனியில் வந்து இன்வெஸ்ட் பண்ண முடியுமா அப்படின்னு. ஸோ அவங்க வந்து கேட்குறாங்க, வாட் வில் யூ கிவ் அஸ் இன் ரிட்டர்ன்? இந்தியன் கம்பெனி சொல்கிறாங்க, வி வில் கிவ் யூ ஈக்விட்டி ஷேர்ஸ் அஸ் ரிட்டர்ன். நாங்கள் வந்து ஈக்விட்டி ஷேர்ஸ் வந்து ரிட்டர்னாக கொடுப்போம். ஸோ அவங்க வந்து அதை ஈக்விட்டி ஷேர்ஸ் வந்து எதில் லிஸ்ட் பண்ணுவீங்க அப்போ அப்படின்னு கேட்குறாங்க. ஸோ அதுக்கு என்னென்னா, தே வில் லிஸ்ட் தேர் ஈக்விட்டி ஷேர்ஸ். They will list their equity shares. It is the equity shares are converted to DR, which is depository receipt. Okay, so foreign investors வந்து they have, so it is converted to depository receipt. So what இது வந்து it is in the custody. It will be in the custody of whom? It will be in the custody of domestic custodian in India. Okay, so இங்கே இருக்கிற equity shares அப்புறம் யாருக்கு போகும்னா, it will go to the overseas depository, foreign overseas depository. It is in foreign. Okay, so like இவங்க foreign investors வந்து for example they are from London. Okay, so Londonல they have very strict rules than Indian depositories. So in the overseas depositories தான் வந்து they will act as owners of the shares. They will act as owners of the equity shares on behalf of the foreign investors. So the foreign investors அப்போ என்ன நேம் பண்ணுவோம்னா, they will be called as the beneficial owners. They are still the owners of the shares, but அவங்க கைக்கு போகிற வரையும் the shares are in hands of the overseas depository. Okay, so this is a brief explanation of GDRS. So next we will get into register of members. Cessation of membership. Cessation of membership, what is that? A person ceases to be a member of a company when his name is removed from its register of members, which may occur in any of the following situations. Cessation of membership now, or a person is no longer in the register of members of the company. So, என்னென்ன ரீசன்ஸ்லாம் இருக்கு? First, he transfers his shares to another person. The transfer is registered by the company and his name is removed from the register of members. His shares is forfeited. His shares are sold by the company to enforce lien. He dies. He is adjudged insolvent. An official assignee disclaims his shares. His redeemable preference shares are redeemed. He resigns the contract of membership on the ground of fraud or misrepresentation. So, he is adjudged insolvent and an official assignee disclaims his shares. His redeemable preference shares are redeemed. He resigns the contract of membership on the ground of fraud or a misrepresentation or a genuine mistake. And his shares are purchased either by another member or by the company itself under an order of the tribunal under section. So his shares are purchased by another member or by the company itself, and the member is a company which is being owned up in India, and the liquidator claims the shares. The company is owned up. Okay. Though one ceases to be a member, he remains liable as a contributory and is also entitled to share in the surplus, if any. Okay. Yeah. So next we'll move on to expulsion of member. Expulsion of member, it is according to section 6 of Companies Act 2013. The act overrides the memorandum and articles of association, and any provision contained in these documents are against the provisions of Companies Act is void. So the Department of Company Affairs is now MCA, has therefore clarified that any assumption of the powers of the Board of Directors to expel a member by alteration of articles of association shall be illegal and void. Next we'll move on to register of members. It is very important. Register of members, we have register of members, section 88 of Companies Act 2013. It lays down that every company shall keep and maintain the following registered in such form and such manner as may be prescribed, namely register of members indicating separately for each class of equity and preference shares held by each member residing in or outside India, register of debenture holders and register of other security holders. So register of members, it is also called ROM. Okay, we have something called foreign register. Okay, we have something called foreign register. What is a foreign register? A part of the register authorized by articles of association. It can keep it in the foreign country where beneficial owners reside. So it is known as a foreign register. A part of the register authorized by articles of association can keep it in the foreign country where beneficial owner reside. Next we have the modalities of members. So modalities of members, we have now on the important forms மட்டும் நான் வந்து சொல்லிக்கிறேன். We have the form. First we have MGT1. The register has to be maintained, and in MGT14 the next register, and thirdly the ROM. The ROM is open to any member, debenture holder or beneficial owner during business hours without payment of any fee or by any other person on payment of such fee not exceeding rupees 50. Fourthly, we have the permanent register. It is maintained during its entire life. Which entire life? The entire life of the business. And next we have the foreign register. So the foreign register, 30 days of opening. MGT3, 30 days of opening is there. MGT3 should be filed to the register. Here we have the meaning of form MGT1. So Rule 3 and 5 of the Companies Act, Management and Administration Rules 2014, it deals with the maintenance of register. It deals with the maintenance of register. Under section 88, it is provided that every company limited by shares shall, from the date of its registration, maintain a register of its members in the form MGT1. Okay. So modalities of members, like every company limited by shares shall maintain a register of members in form MGT1. So நான் சொன்ன மாதிரி so yes, we have first one is we have the MGT1, which is every company limited by shares shall maintain a register of members in the form MGT1. Second, we have the such registers or copies of written may also be kept at any other place in India in which more than 1/10 of the total number of members entered in the register of members reside, if approved by a special resolution passed at the general meeting, SRNG, which is special resolution in general meeting of the company. A copy of the proposed special resolution in advance to be filed with the register at least one day before the date of general meeting of the company in form MGT 14. Next one, we have the entries in such registers shall be made within 7 days. 7 days from the date of approval for transfer approval by the board or allotment done by the board of committee. So an index of members may be maintained by the company of the number of members should not be more than 50. Okay, an index, so it shall include the following materials as follows. In a materials, it shall include the name, address, occupation, status, nationality. So it shall include the name, address, occupation, status, nationality, father, mother or spouse's name, date of becoming member, date of secession, other interests if any. Okay. So yeah, and next, a copy of extracts of such register may be taken by any member, debenture holder or beneficial owner or any other person without any fee or such other fee as may be prescribed. How many fee? Evlo sonne nanu? How much of fee? Rupees 50. A copy of the extracts of such register may be taken. A copy of the extracts of such registers shall be taken by any member, debenture holder or beneficial holder or any other person without any fee or such other fee as may be provided but not exceeding rupees 10. Okay, and the entries in the register shall be authenticated by the company secretary of the company or by any other authorized person of the board. And lastly, it is a permanent register of the company maintained during its entire life. Yes. So yeah. Next, we have the closure of register of members under section 91. Under section 91 of Companies Act. So closure of registers right enadhu, it is எந்த டேட்டில் வந்து the closure of register வந்து ரெக்கார்ட் பண்ணுவாங்க. It is the last record date. So as on this date, the members will receive benefit. Okay. So a company may close. First point I'm reading. A company may close its register of members, debenture holders, security holders for a period not exceeding 30 days. For a period not exceeding 30 days at one time and not exceeding aggregate 45 days in a year. So a company may close its register of members, debenture holders, security holders for a period not exceeding 30 days. So ஒரு குறிப்பிட்ட காலத்துக்கு வந்து அந்த கம்பெனி வந்து அதோட ரெஜிஸ்டர் ஆஃப் மெம்பர்ஸை வந்து 30 டேஸ்க்குள்ளே அது வந்து க்ளோஸ் பண்ணி வச்சுக்கலாம். ஓகேவா? லைக் ரெஜிஸ்டர் ஆஃப் மெம்பர்ஸ், டிபென்ச்சர் ஹோல்டர்ஸ், செக்யூரிட்டி ஹோல்டர்ஸ் இதெல்லாமே. ஓகே, ஒரு வருஷத்தில். A newspaper advertisement. A newspaper advertisement in English and vernacular language newspapers shall be published at least 7 days before the date of such closure. So no security shall be allowed to be transferred during the period of closure. And the record date is an alternative for it is an alternate. The record date is alternate. the record date is an alternate for closing the registers. The purpose of closing the register is to get the registers updated and to fix a cut-off date. So register of members வந்து எதுக்கு வந்து for a period of 30 days or to 45 days in a year வந்து close பண்ணி வைக்கிறாங்கன்னா, the purpose of closing the register is to get the registers updated and to fix a cut-off date for the purpose of payment of dividend or issue of rights and bonus shares. For the purpose of payment of dividend or issue of rights and bonus shares. This purpose can also be achieved by fixing a record date for a day. So in the decided case law, it was held that the provisions of section 91 of Companies Act, the provisions of section 91 of Companies Act 2013 are permissive and not mandatory. The section has application only when a company desires to close its register of members, and in a situation the requirements of section are to be complied with. For example, the case law which is, for example, the case law which is Taylor T. Co. versus Union of India. Taylor T. Co. versus Union of India. So the above mentioned provisions shall not be applicable. The above mentioned provisions shall not be applicable to a private company. So this, the provisions these provisions are not applied. These are not applicable to a private company, provided that the notice has been served to all members of the private company not less than 7 days prior to the closure of register of members of debenture holders or other security holders. Yes. So we'll move on to the next topic, which is preservation of register of returns. Preservation of registers and returns. ஸோ நான் வந்து இந்த டாப்பிக்கை ஈஸியாக அண்டர்ஸ்டாண்ட் பண்ணுற மாதிரி நான் வந்து ஒரு ஃப்ளோ சார்ட் வந்து நான் இப்போ வரைய போகிறேன். யூ கேன் லைக் நீங்கள் வந்து உங்களோட நோட்ஸ்லேயே இல்லை புக்லேயே யூ கேன் ட்ரா இட். ஸோ யா, ப்ரிசர்வேஷன் ஆஃப் ரெஜிஸ்டர் ஆஃப் மெம்பர்ஸில் வி ஹேவ் கம்பெனிலேருந்து 4 பாயிண்ட்ஸ் இருக்குது. என்னென்னா, ஃபர்ஸ்ட் வி ஹேவ் register of members. The register of members is in a permanent form. Okay, next we have the register of debenture holders. We have it for 8 years from the date of redemption. Thirdly, the annual return, it is also from 8 years from its date of filing from its registers. And lastly, we have foreign register, which is permanent unless it is closed. Okay guys, so this is the flow chart for preservation of registers and returns. So நீங்கள் வந்து உங்களோட நோட்ஸ் காலம்ல நீங்கள் வரைஞ்சிக்கிட்டிங்கன்னா உங்களோட லாஸ்ட் டே ஆஃப் எக்ஸாம் ஃபர்ஸ்ட் ரிவிஷன் டேல வந்து யூ கேன் லைக் கோ த்ரூ இட், டக்கு கோ த்ரூ பண்ணிடலாம். ஸோ யூ கேன் ரைட் இட். ஓகே, எஸ். ஸோ திஸ் இஸ் யோர் preservation of register of returns in a simple flow chart. Next we have we'll come to the screen back. Significant beneficial owner. Who is a significant beneficial owner? Significant beneficial owner, who is he? Alone or together, one or more person or trust possess what they possess holds 10% or more share capital indirectly also. Secondly, holds indirectly or together with direct holdings of 10% or more of voting power. Okay. Third, right to receive 10% or more dividend, here also or more. Okay. And lastly, right to receive right to exercise or actually exercise. What to exercise? Control or significant influence. Sorry for my handwriting. So first we have the alone or together, one or more person or trust possess, holds 10% or more share capital indirectly also. Holds indirectly or together with direct holdings which is of 10% or more voting power, or right to receive 10% or more dividend, and right to exercise or actually exercise control or significant influence. We have this case here which is Cyrus mystery case. எந்த கம்பெனி நடந்துச்சு உங்களால் கெஸ் பண்ண முடியுமா? டாட்டாவில் Cyrus mysteryன்னு ஒரு shareholder he holds more than who is a significant beneficial owner, and அவர் வந்து companies வந்து shareholders வந்து they actually did not like him and moved out of the company by casting vote by the shareholders. Okay, எல்லாருக்குமே பிடிக்கல அப்படின்னு சொல்லிட்டு vote cast பண்ணி this person இவரை வந்து வெளியே அனுப்பிச்சிட்டாங்க from Tata. So it was very difficult to get rid of him from the company. So நீங்கள் அந்த கேஸ் ரீட் பண்ணிங்கன்னா you will understand what that means. So guys, நம்ம பார்த்த points is are here. You can like read it. Okay, and significant and beneficial ownership பற்றி சொல்லணும்னா as amended by the Companies Act under section 90. So it provides that every individual who is acting alone or together or throughout one or more persons or trust, including a trust and persons resident outside India, holds beneficial interest of not less than 25%. Beneficial interest of not less than 25% or such other percentage as may be prescribed in the shares of the company, and right to exercise 1 minute or right to exercise or the actual exercising of significant influence or control or defined in clause 27 of section 2 of the Act. So shall make a declaration to the company specifying the nature of its interest and other particulars in such manner and within such period of acquisition of beneficial interest or such rights or any charge therefore may be prescribed. So Cyrus mystery கேஸில் வந்து இப்போ significant beneficial ownershipல வந்து அந்த person வந்து he can declare his own idea on the company, எப்படி வந்து it can run other steps to take the company into another level, அந்த மாதிரி வந்து he should discuss. பட் இவர் என்ன பண்ணார்னா அந்த கம்பெனிக்கு அப்போசிங்காக யாருக்குமே வந்து பிடிக்காத விஷயங்கள் டிஸ்கஸ் பண்ணுறது. பட் he is confident in his matter, but the other shareholders refuse his decisions. ஸோ இது நடந்துகிட்டே இருக்கும்போது மித்ததெல்லாம் சொல்கிறது he does not obey or act, அதுக்கேற்ற மாதிரி he does not act. ஸோ இந்த மாதிரி ரொம்ப நாளாக போயிட்டு இருந்தனால இவரை வந்து இந்த வேலையை விட்டு ரிசைன் பண்ண சொன்னாங்க டாட்டா. But he did not resign because he's a significant beneficial owner. He did not resign, and எவ்வளவோ பண்ணி பார்த்தோம் he did not resign from the company. ஸோ கடைசி என்ன பண்ணாங்கன்னா they casted vote அப்போ அந்த shareholders எல்லாருமே